Good evening. We'll call this meeting to order. This is the May, the 11th Zone of Board of Examiners and Appeals meeting. If that's not the meeting you're looking for, you're probably at the wrong one. A couple of cases tonight. We're going to start with a roll call, please.
Mr. Vig?
Here.
Mr. Cars?
Here.
Ms. Eicher?
Here.
Ms. Dole?
Here.
Ms. McKay?
Here.
Mr. Ayers?
Here.
Ms. Hickok?
Here.
Mr. Hale?
I'm here.
Thank you.
Thank you. We have a whole string of minutes all the way back to 2011, and we'll accept a motion that includes all of these, perhaps 1 through 13, please.
Move to approve. Seconded.
So we have a motion from Ms. McKay, seconded by Ms. Eicher. Does anyone have any corrections to the minutes or need to pull anything? Is there any objections to the minutes, to approving the minutes? Okay, the minutes are approved. On to special order of business. Does anyone have any disclosures? Mr. Ayers.
Mr. Chair, I have worked in the case 2017-0056. My firm did represent the petitioner at the time of construction in 2002. We provided civil engineering and surveying services on that site. Just wanted to note that for the record.
So does anyone feel that Mr. Ayers can't be impartial tonight with this case? Mr. Ayers, would you?
Does Mr. Ayers feel that he can be impartial in this case?
Through the chair, yes, no problem.
Okay.
Okay, then direct him to participate. Do we need a motion to direct Mr. Ayers to participate? Ms. Eicher has a motion and seconded by Ms. McKay. And looks like the yeas have it. Mr. Ayers, you're directed to participate. And on to D, the consent agenda. We have one resolution on there, 2017-001. Does anyone need a motion to approve the consent agenda? Sorry, you guys are going to have to bear with me. Mr. Vig has a motion and seconded by Ms. McKay. Mr. Vig?
Yeah, I move to approve the consent agenda.
Second.
Seconded by Ms. McKay. Mr. Cars, would you like to talk?
Yes, just for the record, I was not in attendance at the April 13th meeting, but I did listen to the minutes, so I feel I can vote on the consent agenda.
Thank you. Is there any objection to accepting the consent agenda as shown. So it's approved. Okay, so we don't have any thing for E, F, or G in the regular agenda, so we'll move right into the public hearings. And we have a couple cases tonight. One is going to be an appeal, and one's going to be for a variance, request for a variance. We'll do the appeal first. Case 2017-0056, which is a request for an extension according to, which is this? It's 21.12.070, Part G. And I believe, with the staff, was there notice given?
Thank you, Mr. Chair. On April 4th, 2017, 472 public hearing notices were sent out to neighboring property owners. Public hearing notices were also mailed to the Sand Lake and Spenard Community Councils.
Thank you, staff. Is there any objections to sufficiency of notice in this case? Seeing none, we can move on. Will the staff please present the case?
Thank you, Mr. Chair. The petitioner requests a time extension until December 31st, 2018 to comply with the standards of AMC 21.11.070 in accordance with the provisions of AMC 21.12.070G, extension of time to comply. Glacier Sign and Lighting was issued a sign permit on March 8th, 2002 for an illuminated double-face freestanding sign with message center to be installed at 5401 Northwood Drive for Diamond Airport parking. At the time of installation, the sign was compliant with municipal code. However, after the sign was installed, several changes to municipal sign regulations were adopted. Because of these regulation changes, this sign was considered non-conforming as of October 1st, 2003. Furthermore, the adoption of AO 2005-163 S2 on May 16, 2006, granted an amortization period of 10 years to come into compliance in accordance with municipal code. AMC 21.12.070B2, amortization of permanent signs, states, any permanent sign exceeding current size or height requirements by greater than 50% must be brought into compliance with this title before May 16, 2016. Which is 10 years from the date of adoption of this provision. The current sign is 45 feet tall and has an area of 980 square feet. These dimensions are above 50% conformance and is in violation of municipal code. To achieve compliance with municipal code, the petitioner shall replace or modify the existing sign in such a manner that brings it into full compliance with municipal code. A comparison of the current sign and standards of municipal code is shown in Exhibit 1A on page 4 of the staff packet. It is unclear why or how there wasn't any action on the side of the petitioner to achieve compliance with municipal sign regulations during the 10-year amortization period. The petitioners indicated in their application that the company has seen some recent turnover which has resulted in a loss of historical property knowledge. It is believed by staff, based upon the materials provided in the application, the lapse of compliance is due to ignorance of the petitioner and not negligence. In evaluating the extension of time for a nonconforming use, the Zoning Board of Examiners and Appeals shall consider the following factors to determine whether or not the owner of the sign has had a reasonable amount of time to recoup his or her investment. Standard 1, the value of the sign at the time of construction and the length of time the sign has been in place. The standard is met. The existing sign was installed in 2002 at a total cost of $202,849. To date, it has seen 15 years of use. It is evident due to the large expense incurred by the petitioner to have the sign constructed and built that that they intended for the sign to have a useful life of approximately 50 years. This estimate is based on the time and use and the remaining useful life of the sign. Standard 2, the life expectancy of the original investment in the sign and its salvage value, if any. The standard is met. The applicant has provided a letter stating that the current sign has a remaining useful life of 35 years. It will be difficult, if not impossible, for the petitioner to recoup any of the installation costs if the sign is not allowed to fully depreciate. The provided salvage value estimate of the sign is $0. Standard number 3, the amount of depreciation and or amortization of the sign already claimed for tax or accounting purposes. The standard is met. The applicant estimates that the current value of the sign is $12,396.34 and will not be fully depreciated until December of 2017. Standard 4, the length of the current tenant lease or expected occupancy compared to the date of the sign is to be brought into compliance. The standard is met. Diamond Airport Parking owns the occupied parcel and intends to maintain the property under its current use indefinitely. Standard number 5, the extent to which the sign is not in compliance with the requirements of this chapter, and the standard is met. The current sign exceeds the dimensional requirements of municipal code by 390% in area and 80% in height. Given that the sign is in substantial noncompliance, it is necessary that the sign come into compliance. The petitioner is requesting additional time to draft plans and construct a code-compliant sign. Standard number 6, the degree to which the board determines that the sign is consistent with the purposes of this chapter. The standard is partially met. This sign was lawfully in compliance between the time of installation in 2002 and October 1st, 2003 in accordance with municipal code. Because the amortization period was established and has ended, the petitioner is ineligible for nonconforming rights under the provisions of AMC 21-12-070. The department finds that standards 1 through 5 are met and standard 6 is partially met. The department recommends approval of the time extension until December 31st, 2018. It will just note the petitioner has included language in their application which alludes to a sign variance as well as draft plans for a new proposed sign. The board is reminded that the only request before them tonight is for an extension of time to comply in accordance with the standards of AMC 21-12-070G. Additionally, we did receive one late public comment from a Mr. Jake Whitaker, last name spelled Whittaker, that was submitted to code enforcement, then passed to us at approximately 3 p.m. today. The public comment reads as quoted, "Please pass this to the zoning board. You cannot find an email to comment on zoning issues on the MOA website. Please make Diamond Parking take down their billboard on International. It is an eyesore and Alaska prohibits billboards for a reason." End quote. Thank you, Mr. Chair.
Thank you. Does anyone on the board have any questions of staff? Ms. McKay.
Through the chair, I have 2 questions. Does the sign have legal nonconforming rights now or not because of the expiration?
Through the chair, no, it does not.
Okay. And then the other question I had is, in your findings, you refer to standards, and yet it says that the Zoning Board of Examiners and Appeals shall considering the following factors to determine whether the owner of the sign has a reasonable amount of time. So are these standards or not?
As stated in code, they are called factors. However, the 2 terms perhaps could be interchangeable.
So would we still have to find that all 6 are met, quote, met?
Through the chair, yes.
Okay, thank you.
Ms. Eicher.
Thank you. Through the chair, I wondered if staff could speak to the decision or discussion, if there was any, about the date for the extension of December 31st, 2018.
Through the chair, the estimation for the sign provided by the petitioner states that the sign will not be fully depreciated until December of 2017. So those dates are going to allow the petitioner to make full use of the sign until December of 2017 and also make use of the full construction season of 2018 to construct a fully compliant sign.
Thank you.
Mr. Vig.
Thank you. Through the chair, can you walk me through your finding on Standard 6 on how that's partially met? I understand that signs that are above 50% nonconformance have a period of time in which to come into compliance, but I'm trying to understand how you came to the conclusion of that standard being partially met.
Through the chair, that factor talks about Chapter 12, of course, the nonconformities. And given that this sign is not eligible for nonconforming rights, at one time it may have been, but currently it's not eligible for nonconforming rights, but is still subject to Chapter 12 and the provisions within Chapter 12. So it's not fully meeting the intent of a nonconformity, giving that it doesn't have nonconforming rights.
Through the chair, Mr. Vig, Dave Whitfield, acting current planning manager. If I could speak to this just briefly. The sign was legally constructed prior to the establishment of this amortization clause. Therefore, it is a legally non-conforming sign. However, because of this amortization clause requiring it to be brought fully into compliance with the title, it is not eligible, being as though it's above 50% of beyond what the code allows for. It has to be brought fully into compliance with code, and therefore is not eligible for non-conforming rights. So it falls under Chapter 12, which is a non-conforming section. However, because of the amortization clause, is not eligible for non-conforming rights.
Okay. Thank you. I also have a question with regard to Standard 5. So we're asked to consider the extent to which the sign is not in compliance with the requirements of this chapter, and if that staff finds that standard is met, and so is it the staff's interpretation of that statement that signs that are more non-compliant than others should be considered for a time extension based on the fact of the degree of their non-conformance?
Through the chair, Chapter 5, or not chapter, the Standard 5 states the extent to which the sign is not in compliance with the requirements of this chapter. So it is considering how far out of compliance they are.
And so a greater nonconformance warrants consideration, and one that's, just a marginal amount above the nonconformity would not?
Through the chair, I believe that is the board's decision.
Okay, well, it kind of comes down to an interpretation of that statement, I think.
Mr. Chair, can we have a minute to discuss this?
Yeah, sure.
Mr. Chair, I believe we have an answer.
Okay, go ahead.
Factor number 5, the extent to which a sign is not in compliance with the requirements of this chapter. It's really a measure whether or not the sign is grossly and how grossly non-compliant they are. And given that staff feels that the sign is grossly non-compliant, however, granting the time extension will allow them additional time to come into compliance given the valuation of the sign.
Thank you.
Are there any other questions from the board of staff? If not, then we'll go into the public testimony, starting with the applicant. So the way we'll do it is we'll ask, 1 second. Sorry, Ms. Stahl, I didn't see you there.
Through the chair, I would like the planning staff to maybe just explain the conditions that are with the department recommendation. If there's any, I guess just the rationale behind those particular conditions. One is that time extension is granted in accordance with 21-1207G and shall come into compliance with the standards of Municipal Code 21-11-070. But the second one is also to provide to planning an approved sign permit to construct a sign that is compliant with the provisions of Municipal Code Section 21.11-070.
Through the chair, thank you. The first condition is just granting, it's just acknowledging that the board approves the time extension through December 1st or December 31st, 2018. The second condition is just making sure that a building permit was obtained for that sign and that everything was done according to the book.
Okay. The first one, I think, confused me because it says the approval shall be subject to it, but so the approval of the extension until December 31st, 2018 is subject to just those sections of the municipal code. Is that what that's saying?
Through the chair, correct.
Okay. And the only other clarification I wanted was just on page 1. There's a reference to October 31st, 2018, and I wanted clarification that you were recommending till December 31st, 2018.
Through the chair, that appears that that is a typo.
Okay.
The request is through December 31st, 2018. I apologize.
Okay. No further questions.
Thank you. Are there any other questions of staff for the board? Okay, we'll move on to the public testimony. And so since this is an appeal, we're going to need to swear people in who are giving testimony. We'll start with the petitioner. And the petitioner has a total of 10 minutes to present your case. You can speak up to 10 minutes. You can reserve your time for rebuttal for later if you like. We've got a clock. It'll start counting down. I think it turns yellow, then red, right? Turns yellow at a minute. So you may want to keep an eye on that. We don't like to cut people off, but if you go too long, we're going to have to. The representative of groups, if you're a community council or something, you've got 5 minutes, and individuals get 3. So I guess what we'll do, we don't have that many people, so we'll swear people in as you come up, if that's all right. So can we get the petitioner's or their representative to come up? Please state your name and spell it for the record, please.
Good evening. Through the chair, members of the board, my name is Don McClintock. I'm a lawyer with the firm of Ashburn and Mason, and here tonight on behalf of Diamond Parking. And my last name is spelled MCCLINTOCK.
Thank you, Mr. McClintock. Do you solemnly swear or affirm that the testimony that you're about to give is the truth?
I do.
Thank you. You have 10 minutes.
Thank you. With me tonight also is Matthew Samuel, the regional manager of Diamond Parking, and John Todd of Glacier Signs. It doesn't appear the factual record is in dispute, but if there are questions regarding cost and the amortization issues, they're certainly available to answer those questions. I hope everyone had a chance to review the additional authorities we submitted on May 5th. There's some legal authority that I think will shed some light on why you have an amortization ordinance. Before going that, I would like to thank staff for walking Mr. Samuels through this process. It is one of first impression, I believe, for this board and for the municipality of Anchorage. And of course, the issue tonight is whether this board will support our request to be allowed additional time to enjoy the benefits of our legally protected investment in this sign. There's no question this sign was legal when it was built. It actually would have enjoyed grandfathered rights, except in 2006. The Assembly decided it wanted an amortization statute to slowly phase out signs. This raises a fairly significant issue, and I think everyone here is familiar with grandfather rights. I mean, buildings, houses, setbacks, many things go out of code compliance as rules change. And in America, we basically respect the property right investments that we have, and we say fine, unless there's a major casualty or unless there's a remodel or something, you get to enjoy that. You get to enjoy the investment, the property decision you made. The amortization statutes, and there are very few of them, tread a little bit more into the taking land. And what the courts have said, and what we cited in our May 5th authority, they said, you know, it's not a one-size-fits-all, because somebody could have a really huge investment, someone could have a small investment. You can't just say, 10 years and you're done. The courts employ what they call a case-by-case or an ad hoc analysis. They like ad hoc because it sounds better, I guess, than case-by-case. But it just says you have to look at all of the factors and make a decision whether this comports with our respect for property rights under our Constitution. And this is, I actually appreciate Mr. Yelley's, I do disagree with his legal interpretation, because you've all seen ordinances where all the factors have to be approved to be assigned. I didn't pull my other butt, but you do have those. I think maybe the variance standard is like that, where you have to meet everything. This one says, these are the factors to consider, and they want you to do a case-by-case analysis. So you don't have to find all six. What you or board are doing is saying, is this a reasonable accommodation for this community to make to someone who made a legal investment and is being asked not only to not enjoy it, but to spend a large sum of money to totally demolish it, and then spend another sum of money to bring something that's into compliance. And to do that, they gave you those six factors. And if you look at the six factors, they're not erroneous. I mean, they're not just happenstance. Those are the ones that the courts talked about when the dispute went to the court, said, well, 10 years, but there was a big investment. Gee, they had tax amortization, but the tax code isn't everything. That's just, you get to write off, against income. What was its useful life? I mean, if it has a 100-year useful life, and it has a 15-year useful life, you have a different one. So you're supposed to look at those factors, make a reasoned decision. And I do agree with the findings that were made in the record at page 21, 22 of staff. They do look at our intent. Our intent is to come into compliance. I would like to point out that this is not an aesthetics question that's in front of you tonight. It is a property value takings question. The Assembly has spoken on aesthetics. They spoke in 2003, and then they spoke again, doubled down, so to speak, in 2006, and said, not only are these the new standards, even if you legally built something before, we're going to make you spend more money later to take it down. It is a property investment question. We know what the standards are, and we know, and we're asking for the additional time to have the commitment to go forward and work something through that allows us to capture as much of our investment as we can and come into conformity with community standards. So I think if you look at issue 5, and the question was asked, you can consider our intent, because the intent is to get this sign, and we get to actually reuse parts of the sign. That is part of the recoupment in the investment as we downsize it. So that is part of the goal we want to go to. I'd just like to say the word billboard is thrown out. Big signs are unpopular. Billboards are unpopular. This is not a billboard. This is a sign. It's a legally placed location identification on one's own property, and everyone's allowed signage. Billboards are off-site advertising, and they're an entirely different creature. They're entitled to an entirely different set of regulations. So that basically is the lie of the land. I would like to reserve my time for rebuttal, because I see there's a few people that I want to have a chance to speak after they speak. But the issue has been brought up. This is brought up after the May 2016 deadline. I think that's unfortunate for us in the sense that if there hadn't been the change in management and someone saw the deadline coming, they could have acted proactively and we wouldn't be here today. But the standards in front of you are not time sensitive. The taking will occur if we were forced to remove this sign today, if we could convince a court that we were entitled constitutionally to more time to amortize. So it's unfortunate today, but it's more unfortunate for us. It's not a bar for this body to hear it. Staff has made that decision. I believe they've conferred with their Department of Law. So I would not get sidetracked on the timing. I mean, it's our loss, but we have to live with that, and that's why we're here today. And I'm happy to take any additional questions, but I would like to reserve my additional time.
Thank you. You've got 3 minutes, 51 seconds left. Does anybody on the board have questions for the applicant?
Okay.
Ms. Hiker?
Oh.
Hi, thank you for your testimony. I do have a question about the time extension request to December 31st, 2018. If I understand the testimony right and correctly and reviewed the materials in the packet, I understand that the depreciation of your amortization is achieved in December 2017. The desire is to have this sign remodeled or replaced during the summer season for construction. So giving the benefit of full amortization with this year and then the construction season being during the summer of 2018, would it be conceivable to move the extension back to the August 2018 during the summer months? That would give you, the petitioner, the benefit of essentially 2 summers and meet your,
Sure.
goal of getting your full amortization schedule.
And, the complexity here and why, of course, when we are asking for permission, we want as much time as we can. I mean, December 31 is definitely in the winter, which we want to avoid. Construction season in Alaska in these balmier years that we're enjoying will often go through October and November, so I don't want to curtail it. And frankly, the big issue we run into is what the permitting process is going to look like as we move forward. So, staff has agreed the December 31, 2018 was appropriate. When you look at the life of the improvement, it could certainly be justified. This sign, at a minimum, has another 20 years of useful life to it, so it's already cutting that factor down dramatically. And since the goal is to move to something that's either in conformity or with the appropriate approvals closer to conformity, we would just appreciate the extra time.
Any other questions? Does the staff have any questions of the applicant?
Okay. Thank you very much.
We'll call up, I guess we'll do representative of groups. Is there any representative of groups here? Would you step forward, please? We'll maybe state your name first and spell it for the record, and then we'll do the swearing-in thing.
Yes, my name is Margaret Auth. The name is Margaret, last name Auth.
Thank you. And do you solemnly swear or affirm that the testimony that you're about to give is the truth?
Yes, I am.
Thank you.
Well, do.
Thank you. You have 5 minutes.
Good evening, ladies and gentlemen. Thank you for this opportunity to speak before the Commission. I am speaking for the Spenard Community Council. I hope you've had a chance to read the letter from our chair, Jed Whitaker, that is part of the packet. This issue is very near and dear to my heart because when this parking lot was first proposed on Northwood, on the north end of International, we, the neighborhood, got out and strenuously objected to it being in a residential neighborhood. We were able to get it on the other side of the road, but we also were extremely unhappy, is a mild way to put it, and the size of the sign. One thing I'd like to point out is even though the attorney for the Diamond Parking, the reason we call it a billboard is because for all intents and purposes it may be lit, but it's a billboard size sign. And I don't know if everybody was here. I was when the billboard initiative was passed in 1998, which they were forbidden for the entire state. And this is one of the reasons that it was so egregious. This is one of the first things that people see when they land. In most people who transit in and out of the state of Alaska through Anchorage, is one of the first things that they see. And it's too big for where it is, and it doesn't have to be that big. Lowe's and Home Depot and other commercial enterprises are able to sort out and get their customers to where they need to go without them being lost. Diamond is virtually by itself on International, so it's not that there's a cluster of signs that they have to get in front of so they can direct people in and out of their lots. The problem is that this sign is just too big for our community, and our community, through our community council, came out very strenuously against this because it doesn't fit in. Now, I realize that I'm not an attorney, and as far as the size of the sign and everything, but the fact of the matter is Diamond Corporation is a family-held business with over 1,000 lots in 7 states and 2 Canadian provinces. They have thousands of personnel that are dealing with all the ins and outs and ordinances of where they are. And I don't think it is the duty of the municipality of Anchorage to notify anybody when the date of noncompliance comes up, because it would be a full-time job. So for one person, and as you know with the budget cuts, we're pretty lean and mean as it is. So I think that it's disingenuous to say that they would have done all this process had they been notified, because I don't think it's fair to us, the community, to now be held hostage to the fact that they didn't do their homework, and now it's for us to give them an additional, well, by then, 2018, it will be 2.5 years past compliance. And we're the ones that bear that every time we go by. And I think that I was dismayed that Mr. Samuels did not come to our community council, although it was on our agenda, and he was told by both myself and the chair that he was welcome to come and speak to us, and decided not to. So, you know, it's one of the few things that the community can do when you have interface with the community. With a corporation, is their representative, and if they decide not to come and speak to the community, then it's a loss for everyone. So I'm also concerned about the fact that they want to go to December 2018, because I agree with this commission member that it would be it's way past the time that they need to bring it into compliance. So thank you.
Thank you. Any board members have any questions? Staff, do you have any questions? Thank you very much for your testimony. And individuals have 3 minutes. Are there individuals that would like to speak? Please come forward. So if you wouldn't mind stating your name and...
Yes. My name is Robert Auth, A-U-T-H.
Thank you. I need to swear you in real quick. Do you solemnly swear or affirm that the testimony that you're about to give is the truth?
I do.
Thank you very much. You have 3 minutes.
Thank you. Thank you for the opportunity. My wife and I are longtime members of the Spenard neighborhood that's very close to this sign, and we've followed it all the way through. I think this sign was the reason why we have a sign ordinance, because it was the size of signs was unlimited at the time this was built, and we could see where it was going if there wasn't limitations put on. And as I recall, when the ordinance came out, and especially with the amortization, the 10-year amortization came out, as my memory is that the city was looking at what other cities had done regarding their signs and what had they put in for an amortization period. And as I recall, this 10-year amortization was considered a very liberal, a very long amortization period for signs to come into compliance. And so there's been the 10 years, and then there's been the 1 year since the notice went out, and now seeking another 1.5 years on top of that. That's a long time. And I would say that the standards 5 and 6 are not met because of that. I don't think a non-conforming sign, a one that's extremely non-conforming, gets more of a break. I think the factor should go the other way, is if it's only slightly non-conforming, you should get an extension of time to bring it into conformity. I think the factor should be looked at from the other way, and I don't think the sign is consistent with the purposes of this chapter, because it is way out of conformity, and so this has been a very this sign has had a lot of effect on the neighborhood. We had a very boisterous community council meeting about it. Everybody that lives in that area has a strong opinion about that sign, because it is so large and it has been part of our neighborhood for so long in a negative way, since it's very big, very bright, very high, and so it's been there long enough. Thank you.
Thank you. Are there other members of the community who would like to speak? Please come forward, state your name and spell it, please.
William Marsh, M-A-R-S-H.
And do you solemnly swear or affirm that the testimony you're about to give is the truth?
I do.
Thank you very much. 3 minutes.
Thank you. I'd like to point out that one of the things that's been lost in the weeds as we discuss the sign and its depreciation and its value is this is the largest non-conforming sign in Anchorage that I'm aware of. For well over a decade, they've enjoyed the added benefit over all of their competition of the largest sign in Anchorage. It is also the most prominently placed non-conforming sign in Anchorage. No value has been given to this item, and any reasonable business, knowing it's facing a non-compliance issue, would have set up a reserve account and forward-funded complete construction based on their estimated costs in the future. This is common in building practices and for anybody that manages a large amount of property. So to say that it's too expensive, we didn't know, is really putting the burden back on the community and continuing the unfair advertising advantage one business has been granted unilaterally over all of the competition. Nobody gets this sign. And we can debate whether it's a billboard or what it is, but what it truly is a bit of an eyesore and doesn't represent our community well or what the intent of. There's a strong indication this sign was the impetus that drove the change of the sign ordinance. And I think that's pretty obvious why. We should become compliant as soon as possible. Building season is year-round in Anchorage. There is almost no building that doesn't get started and completed at any time of the year. That's kind of a red herring. And to discuss how they should have financed what they should have been doing to be compliant with their community standards is just also off in the weeds. They're a business. They're not some mom and pop, oops, grandma forgot the pencil, we didn't put the decimal in the right place. They're a big corporation fully capable of funding these repairs to be compliant. I guess that's all I've got.
Thank you very much.
Mr. Chairman, my name is Tim Potter for the record. I swear to tell the truth.
You solemnly swear or affirm the testimony you're about to give is the truth?
Yes, I do.
Thank you. You have 3 minutes.
Mr. Chairman, members of the board, I had a lot of information to read, and I think the most beneficial thing would be to cut part of it out. Suggest I have white hair, not because I enjoy white hair, but because I've lived through 36 years of land use processing in this town and have been very involved. And if you want context, please ask me questions about what did happen, what was the intent, because after the fact, Monday morning quarterbacking about what the intent really was doesn't necessarily get you there. If you want to know what the intent was there, I was there and I can tell you. So first, I believe that the request for the time extension that's here before you tonight is actually wrongfully and inappropriately before the board tonight. The applicant's attorney, Mr. McClintock, who I respect very much, has has asked you to not get sidetracked on the issue of timing. And I want you to not get sidetracked. I want you to focus on timing, because that was one of the most important things involved with this request and this issue. May 16th, 2016 is a critical date for this discussion. Diamond Parking was not timely. Not timely is a very important term. 2103-030-01 ABC and 2 establishes that requests for time extensions associated with things and processes in Title 21 need to occur on or before the approval lapses or expiration dates expire. Decades of interpretation, policy, and practice reinforce this section of the code. Some of you are familiar with processes like preliminary plat time extensions and expiration dates, recording of final plat deadlines, conditional use permits, and time limits that are associated with those. 120 days formally to accept in writing special limitations for rezones, and posting of public hearing notices that if you don't meet the 21 days, you don't have your hearing. Everything has a date, and there are no exceptions made for those that are not timely. The request for a time extension has to be formally submitted no later than the close of business that date or before. To find otherwise would leave a huge hole lacking definition of what an expiration date really is. Once you allow one mulligan, where does it stop? 1 day, 2 days, 2 weeks, 30 days, 1 year, where does it stop? And what's appropriate? It's a slippery slope. Be very, very careful. AO 2005-163 S2 was adopted in 2006, and it's also very critical to the discussion. Wow. I could complete it in about a minute.
I was going to say, do we have a board member that has a question that might help out with that? Ms. Hickok.
Can I ask Mr. Potter to continue his 2006 train of thought?
Yes, and I'll be as quick as I can.
Thank you.
The S2 speaks to how many versions were actually in front of the Assembly and considered before they actually took action. There was an original, there was an S1, and there was an S2 version, which means there was a lot of deliberation. And in fact, there was a lot of deliberation. In meeting the goals of the community as adopted, in balance with considerations for economic hardships, were the foremost things in the delineation of the Assembly and the debate. The original 7 years for amortization period put forward by Assemblyman Alan Teshi was modified to 10 years because there was a discussion about being totally fair and as much as they could possibly be not have an economic impact on those sign owners. They established a specific process, which is in front of you today in the code, so that if you asked for a time extension, you had a special review done of your specific circumstances, and you were to judge it against those factors. The key is you had to ask for that extension before May 16th of 2016. Again, not timely in this case. Very important consideration. Further, the Assembly said, we're not going to make everybody come down to what the standard is that we approve from a maximum size or height. We'll even accept an allowance within the community aesthetics, whatever, of up to 50% above what those standards said. So there was a further allowance to reduce the number of signs that would be impacted. And lastly, the conformance was really targeted at the most egregious offenders of the signs. And I could go into some things, but since I'm sworn in, I'm not going to. The applicant, Diamond Parking, had knowledge of the rules. Their sign consultant had knowledge of the rules. They could have chosen to bring the sign into conformance at any time up to May 16, 2016. That was 13 or 14 years after the fact of when they constructed it. They could have brought forward a modification to the sign ordinance to make changes. They chose not to. They could have even submitted a letter to the city requesting a time extension to the amortization period specifically for their sign and their circumstances but they chose not to do that by May 16th, 2016 either. They appear before you tonight asking for a mulligan or a wink because they did not take advantage of all the options that the Assembly put forward in 2006 in their ordinance. They have not availed themselves to all those fixes.
Okay, so I'm going to have to cut you off here
And that's fine.
in order to be fair. Ms. Dole, do you have a question? Does anyone else on the board have a question of Mr. Potter? I have kind of a question of staff. I know that it's typical to request an extension prior to something expiring. Why is that not the case in this?
Through the chair, the legal department was consulted on this matter. They had replied back to me that a specific code provision prohibiting ZEBA from hearing this case does not exist, and they advised me to proceed with the public hearing.
Ms. Eicher?
Thank you. Through the chair, I'm sorry. Can you clarify, was it the municipal attorney's office's opinion that ZEBA could hear this case because the extension request for extension was timely and was not precluded?
Through the chair, this specific code reference in 21-12-070G does not state that the petitioner has to apply prior to May 16, 2016, and because of that, there's nothing that prohibits ZEBA from hearing this case.
Thank you.
Are there other questions for Mr. Potter?
Yes.
Ms. Dole?
Through the chair, I believe Mr. Marsh, is that your name?
Potter.
Sorry.
Tim Potter.
Mr. Potter cited to a different section of the code with respect to the provision that requests for time extensions need to be made before the deadline. I wrote down, I don't know if I wrote it down right, but because I'm not sure it looks right, but it's 21.03030. Does that say anything different? And what is the planning's position on the relevance of that provision with respect to timeliness or requests for time extensions?
I have it out to that page, and I can certainly read that portion of the code to you.
I think they have the code in front of them.
Through the chair, Ms. Dole, I did not catch Mr. Potter's code reference there, but if it is in fact correct, 2103.030, that would refer to administrative permits, which I don't think is relevant in this case.
I think that if you go to 2103.030, and yes, it does cover administrative permits, but I believe that that's covering all processes, including plats, conditional uses, all those things. And in it, it very clearly says under O1A, B, and C, it says the lapse of approval timeframes established by the procedures of this title may be extended only when all of the following conditions exist. A, the provisions of this title must expressly allow the extension. B, an extension request must be filed prior to the applicable lapse of approval deadline. And C, the extension request must be in writing and include justification.
So we're talking about 2103030, right? 020.
Mr. Chair. Mr. Chairman, may I request just a short recess to look over the code?
We just need like
Maybe
5 minutes.
5 minutes, please.
Okay, recess for 5 minutes. Is everybody in? All right, go ahead.
Mr. Chair, staff was unaware of this code section. Legal counsel has advised staff to proceed with this case. If the board finds the request was not timely, the board can deny this request.
Through the chair to the board, Dave Whitfield, acting current planning manager. Staff was unaware of this code section. I would say that Mr. Potter has a good point. We've not consulted with our legal counsel with respect to this code section. We've been given direction to move forward on the case. However, if the board decides that this section is relevant and decides that the time extension request was not timely, they could make findings of such and deny the request. So that's staff's position.
Ms. Dole?
Through the chair, I was just wondering if we continued the hearing, heard everyone that came here to testify, but wanted to take additional time to get the benefit of maybe consultation with, the planning department consulting with the municipality's council and considering the matter further. Is there any requirement that we make a decision tonight?
Through the chair, Ms. Dole, the board could make or could postpone the case until the next meeting. So you could make a motion on the floor to postpone, and then we would hear it at the next available zoning board meeting. So we would continue the case. Just a little bit more information to the board. You may want to consider hearing all the testimony tonight, closing the public hearing, and then postponing a decision until you've received additional information from our legal counsel.
Thank you.
Were there other questions from the board? Are there other people in the audience who want to speak? Public members, please come forward, state your name and spell it for the record, please, and I'll have to swear you in.
My name is Irene Pearson Gamble, Persson, and Gamble, Gamble.
Thank you. And do you solemnly swear or affirm that the testimony that you are about to give is the truth?
Yes.
Thank you. You have-
In the sign of the Diamond parking area, which I believe has been up for over 15 years, my parents' home is right in the view of that, and they bought that home, or they bought the lot, built the home, and thought they had a great view of the mountains, and are, elderly. They just recently passed away, and I've inherited the house. And that sign actually is visible from their lot. And my mother was so disgusted. For years, we had to listen to her arguing about Alaska doesn't allow billboards. That sign is a billboard. And they had seen billboards in the lower 48, and they said, Alaska's too beautiful to put up a billboard for advertising when there's so much great nature. So even though they passed away a couple years ago, I now have that house. And I'm like, yeah, Mom is right, and Dad too, that sign really was not, I thought, and they believed legal at the time, and I think they got a variance, which, just drop it and shrink it. I think it's important to have advertising for your business, that's fine, but in that case, that thing is way, way too high, and I believe there was somebody in the political world that said, oh, that's fine, and they got it grandfathered in, if I'm not mistaken about that. So I would just like it to be on the record that I do think that we should not extend that request to have the sign left at that size, even though my parents can't be here to say that. I just got off a plane from Fairbanks, Arctic Council, yay. So I came right here to do that, so I was happy that you're still here so that you could hear that. If anybody has any questions.
Thank you. Does any board members have any questions?
Okay, thanks for
Thank you very much.
considering it not to be extended. Thank you.
And is there anyone else? I don't see anybody else, so we'll close the public hearing.
Actually, Mr. Chair, I'm sorry.
I'm sorry.
I
You
did
have rebuttal
reserve.
time?
Thank you.
What does he have? 351?
I won't engage in the legal argument. I guess that's something I'll take up with counsel. It is unfortunate that this issue is coming up at the hearing and not earlier, but it is what it is. I would like to clarify a few things for the record, though. Mr. Samuels was the person who reached out to the Spenard Community Council and advised them of what was going on, so it wasn't like there was an avoidance of the council. I would like to also note that the fact that Diamond Parking is a privately owned corporation, has lots of parking lots, really is irrelevant to the decisions. I think they're entitled to the same standards that any nonprofit or profit would be entitled to. So, and really the last one is signs and billboards, but this isn't a billboard, but signs are difficult. No one's fond of a sign unless you're looking for someplace or unless you own the sign and you think it's effective. I've been in communities that abolish all signage whatsoever, which is great until you drive past the gas station or whatever. So our community has set a standard. We have made it real clear that the purpose of this extension is to move in that direction of conformity, and we think that the timing issue, one reason why it would be a mistake not to make the findings is if this body is unwilling to do it and there is a conflict or whatever, then that puts that decision-making and the findings in the hands of a judge, when I think the Assembly wanted this body to make that consideration. And we would take, your comments on this seriously. So avoiding the issue by saying it's not our problem, I think, is passing the buck. And I would ask the board to discharge its duty. It does not say in the code that you have to make that application or you forever lose the right. So, but we can talk through that with counsel for the municipality. Thank you.
Thank you very much. And I think that's it. So we'll Ms. Dole has a question. You have a question for the applicant?
I do have a question for the company. In looking at the information in the application, I understand there's going to be there's a permit review process, and that takes time. But I also saw that the company learned in May of 2016 about this problem, and that's been a year ago now. So I just wanted to know kind of what steps had been taken since then to come up with the plan for the changes for the sign or whatever.
Yeah, and it's a very fair question, and it's partly because this is unlike other applications. This is something that's new, and staff and Mr. Samuel spent quite a bit of time figuring out, okay, what application do we make? How do we proceed with this? There was a need to go back and come up with, appropriate signs. You had to actually submit a survey. There were a large number of steps you had to go through to get the application in place. So could it have been done faster? Possibly, but I think everyone was learning their way through the process, so that did account for the time. And then, frankly, some of the time is just your time for advertising, posting, and all of that. So the process is not a fast one, I agree. But the complaint was made just after the week, and I will note that there's no one monitors this. It's on a complaint-only basis. I mean, how many non-conforming signs there are in the municipality is not inventoried at all. So, anyhow.
Okay,
but there was no intentional effort to delay this process, and I would look that question to staff if he detected that sort of effort on Mr. Samuel's part. That certainly wasn't our intention.
Okay. Is that because there's still debate going on as to, depending on the outcome, whether the sign will have to be replaced or just altered, and whether what is required by the code?
The staff's position is that would have to go through a variance process if we were to try to do anything other than come in conformity. So if that was the case, we would have to go through that process again, and I'm fully aware of what the variance process looks like, which is quite a bit different than looking at 6 factors.
Okay, thank you. That answers my question.
Thank you.
Any other questions of the applicant from board members or staff?
Thank you.
Thank you. Okay, I think we've wrapped that up, so we're going to close the public hearing, and the matter will rest with the board. So I guess what we need is a positive motion from somebody, please. Ms. McKay? And seconded.
I move,
I'm sorry, go
excuse
ahead.
me, I move that we postpone this matter to our next meeting.
That's seconded by Ms. Iker.
Yes, I second that motion.
And would you like to speak to your motion?
I just think that there's too many questions that need to be answered before we can actually make an informed decision.
Ms. Iker?
I specifically would like to resolve the question of whether or not this matter is ripe before us. I am concerned that if the request for an extension was not made timely, that we shouldn't be hearing this matter. So I would hate to make a decision and move forward and have adverse consequences on that end. So that's the threshold question that I would like the staff, with consultation to the municipal attorney's office, to resolve for my benefit.
Yeah, I think I have to agree too. Are there other Other comments on this? Ms. Stoll?
In addition to the ripeness question, I would be interested in any further feedback on the factors and how they are, well, either individually, but as in the question that came up with regard to factor 5, but also there's been some discussion here as to whether they are like the variance standards where they all need to be satisfied, or whether these are just factors that the board considers and weighs in reaching a decision.
And do we need to specify a certain date? I mean, to see this the next meeting, or?
I said next meeting, and that was the...
Oh, I'm sorry.
Yeah.
Any other comments on this before we vote? Anyone say something? Okay, please vote. And we have the votes in, and they are yeas, so this will be postponed until the next one. We'll look at this again, and I'll take a break and look at it a little closer. Thanks to everybody for coming in for this. Sorry for the delay. So we have one more case tonight. That is case number 2017-0058, dimensional variance from table 21.0601. And will the staff please describe the notice given in this case?
Thank you, Mr. Chair. On April 4th, 2017, a total of 230 public hearing notices were mailed. No responses were received from the public, and no comment was received from Scenic Hills or Basher Community Council.
Thank you. Does anyone on the board have any objection to the sufficiency of notice in this case? Seeing none, it seems to be sufficient. So will the staff please present the case?
Thank you, Mr. Chair. Okay, so this is a request for variance from AMC Table 2106-1, which is the dimensional standards, to allow an existing permitted single-family residence to encroach 2.6 feet into the required side setback in the R2A district. The minimum side setback is 5 feet. So the existing house was constructed in 2006 and received a certificate of occupancy on July 2008. The owner at the time then sold the property to Donna Merdan in 2010. After the sale, it was discovered that an error had been made on the survey provided to the Merdans. The as-built provided by Gastaldi Land Survey shows that the structure encroaches 2.6 feet into the 5-foot side setback. This is along the north property line. So the homeowner attempted with the municipality, they submitted a preliminary plat for the property to correct the side setback violation. They received preliminary plat approval, and then the neighboring property owner would not sign the plat, so the plat expired. They exhausted that procedure of trying to replat the property, and that was not possible. So the variance request in front of us is the result of the faulty as-built surveys for lot 43. The petitioner currently is unable to sell her property and is seeking a variance to allow her to do so. Staff finds, let's see here, we'll call them A through H. If staff finds that A through H have been met, the error seems to be the result of a building error compounded by faulty as-built surveys. The municipality relied on that plot plan dated 3/20/2006, and then the as-built dated July 7th, 2006, when issuing the building permit and certificate of occupancy. The lending agencies and buyers depended on this faulty as-built when the property was sold. Strict application of the code would create an undue hardship on the current owner of the property. The municipality, current owner, and lending institutions at the time of the sale had no reason to reject the survey as they rely on the accuracy of the as-built surveys and the surveyor's stamp. The error is not self-imposed and did not result from actions of the current owners of the property. Planning staff reviewed a 2014 aerial photo that shows that there appears to be adequate space between the structure on Lot 43, which is the petition site, and Lot 44 to the north, which is the neighbor, to allow for light, air, open space, and fire separation. This variance will not change the character of a zoning district. If the variance is granted, it would not allow a use not permitted within that district. The request should have little to no negative impact to the neighboring residents. And the variance is the minimum variance that will allow the structure to remain without requiring the building to be reduced in size to provide a 5-foot side setback. So with that, the department finds that all the standards of approval are met and is recommending approval of the variance subject to the 2 conditions found on page 5 of the staff packet. I'll be happy to answer any questions. And I believe the petitioner is here as well. Thanks.
So could I ask a quick question of you? I'm looking at the as-built, and I'm looking at the plot plan, and I noticed that the north line to the building doesn't have a dimension on it. Is that typically acceptable to the folks at the Muni?
Mr. Chair, I believe it's at the time when they would put a scale on it. They have to provide a scale, then it would have scaled. Yes, it isn't dimensioned. I'm not sure. They may or may not. The person who signed off on that probably scaled it and saw that it met the 5-foot setback.
Are there questions of staff by the board? Mr. Cars?
Yes, thank you. Through the chair, looking at the current as-built, it appears there's a fence on that lot line that's actually on the adjacent property, lot 44. Just for my clarification on the record, and I'd ask the applicant as well, the board's not approving that fence location, or I don't notice that there's a requirement to relocate that fence.
Through the
Can
chair,
you speak to that, please?
Yeah, through the chair, Mr. Cars. You are correct. The board in front of you tonight is only for the structure setback, not the fence. The municipality considers the fence a civil matter between the 2 property owners. If the other property owner is fine with it, it's perfectly fine to keep it there. If they want to move it, once again, it's just a civil matter between the 2 property owners. The municipality doesn't get involved with the fence. Does that answer your question?
Yes, thank you.
Okay, thanks.
Any other questions of staff? So we'll go into the public hearing. Looks like we have the applicant here, perhaps somebody else. So the applicant, please come forward, state your name and spell it for us, please.
My name is Annette DeLong. I'm here to speak on behalf of Mrs. Murdan. My name is spelled A-N-N-E-T-T-E, last name D-E, capital L-O-N-G.
Okay, thank you. You have 10 minutes, and we don't need to actually swear you in for that.
No, we're here because the variance is being requested. First of all, thank you for the opportunity to request the variance and for your service to our community. The Mrs. Murdan last year, when her husband passed away, she went to sell the house, and it was discovered that there was a problem. She purchased the home with her husband and not knowing of this issue, and was even issued title insurance based upon the faulty surveys. There was a request to actually replat, and that was not possible after a large amount of money and effort was expended to go that route. There exists exceptional circumstances. We could go through the application again, but we believe we've met all the standards of the municipality to grant the variance and would request that you do so.
And I assume you'd like your 8 minutes and 40 seconds for rebuttal. Does the board have any questions of the applicant? Mr. Cars?
Thank you, through the chair. And just a point of clarification again, and I appreciate Mr. Odell's response to my question. Also looking at it to protect the adjacent property owner's right that if they so chose to relocate that fence onto the property line, they have the right to do that. And just so you and the applicant are aware of that.
Yes.
Thank you.
Ms. Dole?
I was wondering when the corrected survey, when the problem was discovered, was it discovered there were any monuments on the ground that were there in there, or what do you know what led to finding the problem with the previous surveys?
You know, I don't know the exact circumstances other than when the sale was to occur last year, the surveyor found that there was a variance at that point.
Okay, so you don't know if there was anything on the ground that maybe...
No, I'm not aware of anything on the ground.
And then I'm really just curious why the lien holder would not agree to the replat when that was attempted.
The lien holder would not say what the problem was, but they just refused because of the circumstances with the borrower to sign. One could assume that there could be some legal action involved.
Yeah, thank you.
Are there other questions of the applicant? Would you like to use your rebuttal time?
No.
Thank you.
Thank you.
Would you like to speak at all? Okay. Okay, we'll close the public hearing then, if no one has any other comments. And the matter rests with the board, so may I have a positive motion, please? Mr. Vig.
Mr. Chairman, I move in case 2017-0058 that we grant a variance from AMC Table 21.06-1 to permit an existing single-family residence encroaching into the side setback, subject to staff recommendations 1 and 2 on page 5 of the packet.
Seconded by Mr. Ayers. Would you like to speak to your motion, Mr. Vig?
Yes, thank you, Mr. Chair. I concur with staff's findings in this case, A through H. Briefly speak to them. I do agree that there are exceptional and extraordinary circumstances when the applicant relied on previous work conducted by professional land surveyors that was found later to be in error. And the applicant and the municipality have or should be able to rely on that information. So I believe that standard's met. I believe standard B is met, and that strict application of this code would create an undue or exceptional hardship on the property owner. Certainly, the relocation of the residence is not economically feasible, and preventing the applicant from selling the home is an undue hardship. C, the hardship is not self-imposed. I agree with staff that this is not a self-imposed hardship, and again, the applicant relied on work provided by others and to which the municipal staff relied on. So I believe that standard is met, as well as standard D. It won't adversely affect the use of adjacent property. Standard E, I agree with staff that that's met. It would not change the character of the zoning district, granting the variance. Standard F, it would not affect health, safety, and welfare of the people of the municipality. I agree that that standard is met. Standard G, again, agree with staff. Granting the variance would not be related to ADA accessibility. And then finally, Standard H, it's the minimum variance that would make possibly reasonable use of the land, and I agree that that standard is met, and I intend to support the motion.
Thank you, Mr. Vig. Mr. Ayers.
Through the chair, I concur with Mr. Vig and staff's findings. I would also like to encourage the petitioner to report this faulty survey to the licensing board, the state of Alaska. It's not the first time we've seen this particular individual with this exact same problem, and the only way that's going to be resolved is if people speak up. I will be supporting the motion.
Thank you, Mr. Ayers. Ms. Dole.
I'm supporting the motion as well, and I agree with staff on standards B through H. I also agree on A, but for slightly different reasons. A speaks to seems like more the physical characteristics of the property that warrant a grant of a variance, and I believe that we've found in other situations that an existing building or structure on the land can be a physical particularity, and so that's part of my reasoning on A.
Thank you, Ms. Dole. Any other comments before we vote? Seeing none, is everyone ready to vote? And the ayes have it. Motion passes. Thank you very much for coming in. That ends that case. And you guys don't need to stick around if you don't want to. Thanks for coming in. And just what happened to my agenda? No. I said it's colored. I wasn't aware that I needed to prepare a report, so I didn't. Does anyone have a report? And board comments? Mr. Ayers?
I will not be here next month.
Good comment. Any other board comments? I think we need a motion to adjourn. Ms. Stoll.
I move to adjourn.
Seconder, Mr. Cars. Any objection? Seeing none, we are adjourned. Thank you.